Okay, good morning. We're just waiting for the jail to get Mr. Warner into a Zoom pod.
Great, thank you, Your Honor.
There we are. Okay, this is file 24-218441-FC, People of the State of Michigan versus Dale Warner. We are here today for hearings on several motions. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is participating via Zoom, as am I.
All right, and as I indicated, we do have several motions today, one from the people and several from the defense. So let's start with the people's motion to compel discovery.
Your Honor, I received a witness list from defense last Monday, and I did send a follow-up email requesting contact information from 3 people. And I know Ms. Chartier said she would get that to me. So I expect that to be coming. Other than that, I believe I have what I need from Ms. Chartier.
Okay, so it sounds to me that you don't feel any further order at this point is necessary. Is that
I would just ask Ms. Chartier to confirm that she is going to be sending me that contact information.
I will definitely this week. So Ms. Wise requested the contact information to a paralegal. She emailed the paralegal who had emailed the witness list to her. Because of the holidays, she's been out. I have not had a chance to check her email yet today, just because the hearing started at 8 a.m., but I will. If I don't get it to Ms. Wise today, I should be getting it to her tomorrow. But I don't see any reason why I can't get the phone numbers to her today.
I'm satisfied, Your Honor.
okay? All right, that leaves us then with the defense motions. Ms. Chartier, I'll let you start wherever you would prefer.
Thank you. So we filed 4. I won't be repetitive of what's in the brief. I'll just hit some of the highlights. So the first one is the motion for additional peremptory challenges. As this court is aware, there are 12 each that each side will get because this is a life offense. When courts have granted this in the past, while courts have the discretion to only give one side additional peremptories, if this court were inclined to give the defense additional peremptories, we certainly don't object if the government would seek more as well. The good cause here, which is required under the statute, quite frankly, is the significant media coverage as well as the significant community opinion that appears to exist to a large part to Mr. Warner's detriment. So I know when we brought the motion for a change of venue, we articulated that in the Justice for D page, there had been communications or posts about being a stealth juror, and that's still our concern. The concern is that people will say the right things in order to at least be able to be seated on the jury. And as this court knows, it's not only about what people say, but it's also about how people say it. So someone may say, well, yes, I had this opinion, but I can be fair and impartial. That's really not enough to be a seated juror in this case. And while that may not rise to the level of cause, depending on what the court's determination is, it certainly would indicate a need for a peremptory challenge to us. And obviously, each juror is an individual, and we would certainly delve into what they have to say, what their thoughts and opinions are. But my concern is that people may say the right things to be seated, and then with only 12 peremptories, we cannot protect Mr. Warner's constitutional rights.
What?
Your Honor, this court, I believe, has set it up for approximately 700 potential jurors to be brought in and has allowed for individual juror questioning. I believe it's up to the parties in the court to determine, yes, while some jurors may say that they are able to be fair and impartial, I believe that further questioning will get us to whether they can actually be fair and impartial. And I believe the court has enough things in play to weed out those jurors. So I would ask the court to deny this motion at this time.
Ms. Chartier, I'll give you an opportunity at rebuttal if you care for it.
The only thing I would ask is if the court is inclined to deny the motion, I would ask the court to deny it without prejudice so that if the need comes up during jury selection, we can renew that request with the court. And I'll be frank, a lot of it depends on some judges are much more strict with challenges for cause than others. And so a lot of it depends on where we land with that during jury selection. We've had additional peremptories before and we haven't had the need to use them because courts have been more liberal with challenges for cause and vice versa. So if the court is inclined to deny, I would just ask it to be without prejudice so we can renew. Thank you.
Okay, it is clear that there has been a large amount of media and social media coverage and interest in this case. That has been the topic of prior hearings. In response to that, the court has called in a significantly larger number of jurors than it would normally call in even for a capital case. I think that additional number of jurors, in my mind, supports the increase in peremptory challenges. I do think there's a concern here that first, that we're likely to excuse a large number of jurors for cause, but there has been some indication that there are some people who may be interested in trying to get on the jury when they shouldn't be. That social media post has previously been provided to the court, and I think we need to take that concern seriously. I do think that supports a finding of good cause to increase the number of peremptory challenges in this case. And as I said, I'm more comfortable doing that given that we have a significantly larger normal number of jurors that will be in the pool. So at this point, I would grant that motion and increase the number of peremptory challenges for each side to 18 from the 12 they would normally get, so a 50% increase in the number of peremptory challenges.
Thank you, Your Honor.
All right, which motion would you like to address next?
The jail calls, please. So I'll wait till the court's ready. Sorry.
Go ahead.
Okay. So the court is well aware that we had filed a motion to preclude the use of 2 jail calls or any other jail calls that the government sought to admit, and the court denied that. The court did grant our request for all of Mr. Warner's jail calls to be sent to us. We have gone through those, and I will tell you I was surprised when I was listening to one and I heard voices familiar, and then I realized it's my voice, Mr. Head's voice, voices from our office, voices from the Head Murphy law firm. And as I went through, I thought, well, maybe that was just a mistake. Someone happened to record that by mistake, and it wasn't a mistake. Then when we had the hearing the last time in court, Detective Drurior admitted that he is listening to attorney-client phone calls on the jail line. And that was extremely surprising to me because when there's a wiretap, for instance, in federal court, you frequently will have wiretaps on clients' phones. The order always indicates to not listen to privileged calls. And so when you get the calls from the government where they're wiretapping your client's telephone calls, when you get a privileged call, either with a doctor or more frequently with their lawyers, you'll hear it say minimize. And then the rest of the call was never listened to. It was never recorded. Here, not only were the calls recorded by the jail, but then they were turned over to the police, and then they listened to all of them with no attempt, according to Detective Drurior, to stop listening once they realized they were attorney-client calls. He indicated he was on the treadmill, and then he just kept listening. And some of those calls go 12, 15, 20 minutes long. It was shocking to me how nonchalant he was about listening to attorney-client communications between Mr. Warner and myself and the Head Murphy law firm. He's working out. It's not like he's bedridden. He could have jumped off the treadmill and moved on to the next call. He chose not to do that. And then I was even more surprised, quite frankly, when I got the prosecutor's response that they don't think there's anything wrong with that. And presumably those calls have been turned over to the prosecutor. I was actually operating, probably mistakenly, under the assumption that those calls were not turned over to the prosecutor, but based on their response, they very well may be. So for the number of years, essentially, or certainly significant number of months that Mr. Warner has been locked up, people have been listening to his attorney-client calls. I mean, it has an unbelievable chilling effect. Mr. Warner called our office. Honestly, I said, tell him I'm not going to take the call. I'll visit with him instead. But then I'm quite frankly concerned about, if I do a video visit with him, are they now recording that and turning that over? If I meet with him in person, is someone flipping a switch and listening to the communication? The lack of concern for respecting privilege is quite frankly chilling. But what's even more concerning is the prosecutor just going along with that. If the jail records the calls, I don't think they should. But regardless of that, even if they do, once the police know that they are listening to an attorney-client call, they should stop listening, not just double down, listen to it, and proudly state on the stand that they are listening to it. I struggled with, quite frankly, what's the remedy here? I've never had this happen in all my years. I do know colleagues around the country who've had this happen, but I always thought, well, that's such an anomaly. I can't imagine anyone in Michigan who I've ever worked with doing that. Well, now I certainly can imagine that because it's happened to Mr. Warner. What is the remedy here? I mean, the remedy at a minimum is an order saying stop listening to Mr. Warner's attorney-client calls. But does that go far enough? I leave it to the court's discretion. I mean, remedies can range from dismissal of the charges to sanctions to jury instructions. The damage, though, is done here. So it's so difficult to fashion a remedy to talk about you should never have been listening to his attorney-client calls from the beginning, which is such a basic concept that, quite frankly, I was shocked I had to file the motion, and then I was shocked at the response that I received.
Ms. Weiss?
Your Honor, in this case, the attorney has the ability to go to the jail and meet with her client. She has the ability to set up her phone number with the jail to have that protected conversation. But to say that she's shocked by the fact that they were being recorded, I have never listened to any of her attorney calls. Nobody's ever called me and said, oh, guess what he was talking about with his attorney. So before this motion was brought, when Ms. Chartier brought it up with me, I didn't know these were being recorded. However, after I got this motion and researched this, I went back and listened for numbers that I didn't recognize. One of the calls, all of the calls say, this is a free call from Dale, an inmate at the Lenawee County Jail. To accept this call, press 0. To refuse the call, hang up or press 1. This call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL. On one of those calls with the number I didn't recognize, as soon as the called party answered, Ms. Chartier responds, Dale, hi. So to say she had no notice that those calls were being recorded is without merit, Your Honor. And the case law is very specific that this is not a confidential communication when they waive the privilege based on that message that was on the phone.
Ms. Chartier?
Thank you. So I spoke to Mr. Warner. He indicates that there is not an option for him at the jail to segregate out attorney-client privileged calls. Yes, it says the call is recorded. Obviously, now Ms. Wise has listened to my calls if she knows I say, hi, Dale, on it. Whether the jail records the call for security purposes, which the court has already deemed that they can, but then the police and prosecutor listen to those calls are two separate things. There is no security interest for the police to listen to Dale Warner's calls with his lawyers. And I would ask at a minimum for an order telling them to stop doing it. Yes, we can go visit our client in jail, but they also have phones for a reason. And the hours where we can visit our client are restricted because of what the jail has to accomplish. No one is complaining about that. Jails have restricted hours all the time. But sometimes you need to communicate with your client via phone. And the fact that the government thinks that the police can listen to it at will is extremely concerning.
So, Ms. Wise, there is a method by which Ms. Chartier could have her calls not be recorded by the jail.
Absolutely. I confirmed that with the jail captain when I received this motion.
And how would she go about, or Mr. Warner go about doing that?
They need to get with somebody at the jail, a jail sergeant, the lieutenant, the captain, and provide that attorney phone number that they have to exclude from those phone calls. They have to confirm that that's an attorney, then they provide it to the GTL, which will then exclude it from any of those recorded conversations.
All right.
Who is the, may I ask, I'm sorry. May I ask who is
Go
the
ahead.
jail captain? Because when I spoke to Mr. Warner, I had asked him that specific question, and he had indicated that there was no method for him to segregate out attorney phone numbers. Some jails have that method, other jails don't. It generally comes from the client, and then it's confirmed with the law firm. So Mr. Warner said that that was not an option. If it is an option, I'd like to make sure I know who is indicated that it is an option. So may I ask who the jail captain is who you spoke with?
Absolutely. Captain Randy Casey.
Okay, thank you.
All right, with respect to any request for a remedy for having listened to calls up until today, I think that the case law is clear and that it supports Ms. Wise's position. The people have cited to an unpublished case of People versus Miller. I do recognize that it is unpublished and therefore it's not precedentially binding upon this court. However, I do find the logic in that case to be sound and compelling. I think it appropriately states the law, and it is based on People versus Campo, which is a published case by the Michigan Court of Appeals, which sets forth the same principle in a slightly different context. And that is that where a person knows that other people are listening to a conversation, they have waived the attorney-client privilege, and I think that is what has happened here. There doesn't seem to be any dispute that the calls between Mr. Warner and his attorney came with a recorded message at the beginning of each and every call that advised both sides in that call that the call was being recorded, and so that other people were listening in. Having proceeded with the call after that, the confidentiality at that point has been waived, and there's no violation by the people listening to that call. Because again, the element of confidentiality does not exist in that context. So I would deny that motion. However, I do think we have established a process by which Ms. Chartier and Mr. Warner can communicate by telephone without having calls recorded, and have an expectation of confidentiality in those calls going forward.
Thank you, Your Honor.
Okay, and which motion would you like to move to next?
The Daubert motion on Michelle Ponchke, who is the paint analyst.
All right, go ahead.
Thank you. This court is well aware, I believe, of the standard required by Daubert. So essentially, the testimony of the proposed expert witness must be relevant. It also must be scientifically valid. And in Craig versus Oakwood Hospital from the Michigan Supreme Court, there has to be a general acknowledgement of the legitimacy of the testing. The testing has to be grounded in scientific principles and methodologies, and the validity of the testing cannot be based on a subjective belief or unsupported speculation. And essentially, it has to be reliable. The burden of proof rests on the government to prove that it is admissible, and the expert through the government, has to establish the reliability of the principles and methods to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. In Gilbert, which is another Michigan Supreme Court case, the court laid out 4 separate criteria, and we have none of it in this case. The data underlying the expert's testimony must be substantial and trustworthy. We don't know that in this paint analysis. The manner in which the expert interprets and extrapolates from the data is reasonable and sound. We don't know that. The opinions based on the data express conclusions reached through reliable principles and methodologies. We don't know that. And the expert is qualified to provide opinions that are in the scope of the individual's expertise. We don't know that. We don't even know what her credentials are to examine paint. So we don't have any of the underlying foundation to even let in testimony about paint analysis. But even beyond that, when we get to the relevancy of it, the lab analyst is essentially saying, well, we looked at some paint on Mr. Warner's property. Some of the samples match, some of the samples don't. It could have come from the paint on the property, or it might not have. And then to put it in a context which the court knows, they're analyzing the upper layer of the paint on the tank where Ms. Warner's body was found. So the conclusion of the analyst is it could have come from the same source, or it could have come from a different source. That's certainly not relevant, because an individual source can't be determined, or cannot even be determined with any sort of statistical probability, so that we know, okay, how many cans of this paint are actually produced in a year? How many of it are sold in Michigan? Is this common on farms? It sure seems like it would be. So for all those reasons, I don't believe that Ms. Ponchke should be allowed to testify, because none of the basis of Daubert has been established here. If the court obviously disagrees with me, then I would ask the court for a Daubert hearing in which we could question Ms. Ponchke, as well the government can put their proofs on, to determine if the science is really valid here and if it was applied reliably to the facts of this case. Now, I recognize we have trial coming up in a month or a little less than that, but there certainly is ample time for a Daubert hearing. I don't think that it would be a lengthy process. We also have the roughly 2 weeks of jury selection if we needed to, try to fit something in there. So I would ask the court to grant my motion. Thank you.
Your Honor, as to the relevance of the testimony about the paint, it is relevant because it goes to means and opportunity. Under People v. Hall 433 Mich 573 and People v. Houston 261 Mich 463. Both of those cases involved defendant being arrested, subsequently in possession of a firearm that they weren't able to say was the firearm used in the crime that was committed. However, it was similar in kind to that to which the crime was committed. And the court said those were admissible because they go to means and opportunity. I've submitted the lab report with my response to the court, so the court can see that, again, some of the paint samples did not match, some of them did. I think that it goes to the weight the jury decides to give it, not to its admissibility. It is relevant. However, if the court would want to grant the Daubert hearing, we would have no objection to holding that hearing.
Anything else on this one, Ms. Sharkey?
No, Your Honor, I say no, and then I keep talking. But the only thing is, I think if the court is not going to exclude, I think a Daubert analysis will get to at least the major concerns that I have, with the exception of the relevancy. But again, we don't even know how the science was conducted here. And so a Daubert hearing will at least help us get there.
Okay, the way that the court establishes whether or not an expert can testify in case is to conduct a Daubert hearing. I do think that's completely appropriate in this case before the court makes a decision. So I would ask you to schedule that. Perhaps when we're done here, you can contact Sierra Francis offline. And I think we should have some time available before the trial begins in order to get that done.
Thank you, Your Honor.
Okay, I think that leaves only the motion for a spoliation instruction.
Thank you, Your Honor. I would ask for that instruction to be given based on the testimony of both Detective Drurior and retired Detective Singleton that text messages were destroyed. We know that they did not record every aspect of interviews. We know that they didn't necessarily record even some interviews or conversations they had with people or even log it down. When I was questioning both Detective Drurior and Detective Singleton, their response was, well, we didn't preserve text messages, but we don't know how they got deleted off our phone. It may just be a policy or procedure of MSP where things are deleted a year after they're on the phone, whatever it may be. That seemed questionable to me, but that was their testimony. But then we received typed text messages from the government that Greg Hardy had purportedly given to them. So essentially, rather than taking screenshots of his phone or rather than turning his phone over so that there could be a download, he typed messages during a particular time frame. Not all the messages on his phone, but just the ones during the time frame that he believed that Detective Drurior sent his messages over. When we compared the messages side by side, it was clear that the destruction wasn't based on some policy or procedure that Detective Drurior was unaware of, because there are 3 messages that Greg Hardy turned over that he typed. So purportedly they are real messages that Detective Drurior did not turn over. But the other one that is significant is Detective Drurior had turned over a screenshot of a message exchange between himself and Mr. Hardy. But when Mr. Hardy typed up that same exchange, there were sentences missing. And this would be within the 1-year time frame. So there's literally no reason why that aspect of the message wouldn't have been turned over other than Detective Drurior decided he didn't want to turn it over. He either deleted it from his phone or he just chose not to turn it over. That is bad faith 100%. There is no other way to frame that. It is an intentional withholding of evidence from the defense. And the government's notion through the police seems to be, well, we determine what's of evidentiary value. And so if we don't think it's of evidentiary value, we can destroy it. We can delete it. It doesn't matter. But it's the defense's right to see evidence. It's the defense's right to determine if evidence is valid or not valid. And we cited a quote in there from Jenks versus the United States, from the United States Supreme Court, which aptly articulates our position on this, because only the defense is adequately equipped to determine the effective use for purposes of discrediting the government's witness and thereby furthering the accused defense. The defense must initially be entitled to see the discovery requested to determine what use may be made of them. Justice requires no less. So it is not for Detective Drurior to determine, well, these messages don't matter, I'm going to delete them. These messages don't matter, I'm not going to turn them over. He has a job, he swore an oath to turn over evidence. And it's not just his determination of what has evidentiary value. And we know from the messages that were turned over that they do have evidentiary value to the defense. So I would ask for an instruction to be given to the jury, because we cannot argue that the messages were exculpatory that haven't been turned over, because we haven't seen them, because they have been destroyed. But we do know that they were intentionally destroyed. And so in that case, we don't have to show bad faith, or excuse me, it is not a matter of good or bad faith, which it is with exculpatory evidence. Here, we have to show bad faith, and I believe that we have, by the intentional destruction and by the intentional destruction in omission in this 1-year time period where Greg Hardy has proven that Detective Drurior did not turn over everything that was on his phone. Thank you.
Your Honor, the due process clause does not impose an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Here, Detectives Drurior and Singleton both testified that it was their common practice and procedure to take those messages that they believed were of evidentiary value, document them, and then delete the messages. Detective Dreer is the one that asked Greg Hardy if he had a copy of their text messages to provide to the defense. That can't be said that Detective Dreer acted in bad faith or that Detective Singleton acted in bad faith. Based on the law that I provided the court, I'd ask the court to deny the motion. Based on the very definition of spoliation, Your Honor, there was no intentional destruction of evidence with the purpose of rendering it inaccessible or useless to the defendant. Therefore, they're not entitled to the spoliation instruction.
So that doesn't seem to match up with the police report that we got in the text messages. So according to the police report, Greg Hardy provides a folder of documents that contain text messages. So there's no indication that that Detective Dreer asked for them. The police report says Greg Hardy called me on 12/5/25. I asked Greg about the documents messages that he provided. He stated he provided the messages for the time frame that were in question and has additional messages on his phone. Greg stated it took great effort to document them and it was not an easy process. And I believe that in another email or text message exchange, Greg Hardy indicates that he's been trying to get in touch with, I believe it's Detective Dreer, but nobody is responding back to him. So the notion that he asked for the messages seems to be belied by the evidence that they've turned over themselves. So again, so this is from Greg Hardy on December 2nd, 2025. It's an email from Greg Hardy to Jackie Wise. I've made a copy of text messages that you had requested previously between Dreer and I for the time period that apparently is in question. I have left numerous messages for you and Lee with no response. Do you want the text messages or not? So Detective Dreer isn't asking for those messages. The prosecutor is. So it's not like Detective Dreer is trying to fix this problem that he created. If anything, the prosecutor is trying to, but then Greg couldn't get a hold of anybody. So he came in with at least partial messages. But the messages show that Detective Dreer intentionally destroyed evidence.
All right, I'll touch on Brady briefly since it was briefed, although I understand the arguments to be that defense is not pursuing a Brady violation at this point. But Brady versus Maryland held that suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or punishment, irrespective of bad faith. In order to establish a Brady violation, evidence is favorable to the accused when it is either exculpatory or impeaching. In this case, there isn't any evidence that the deleted text messages were either exculpatory or impeaching. And therefore, the defense cannot establish a Brady violation. Arizona versus Youngblood established the rule that where potentially exculpatory evidence is permanently lost, a defendant must show bad faith on the part of the police in order to establish denial of due process. United States Supreme Court in Youngblood indicated an unwillingness to read the fundamental fairness requirement of the due process clause as imposing on the police an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Rather, the Supreme Court stated, we think that requiring a defendant to show bad faith on the part of police limits the extent of the police's obligation, limits the extent of the police's obligation to preserve evidence to reasonable bounds and confines it to cases where the interests of justice require it, i.e. those cases in which the police themselves, by their conduct, indicate that evidence could form a basis for exonerating the defendant. The evidence before the court at this point is that certain text messages between detectives and witnesses were deleted. The officers both testified that they preserved anything that they determined to be of evidentiary value and did not preserve other texts that dealt with things like logistical issues and setting up meetings. They both testified that this was consistent with their training and experience. For example, the deleted text messages referenced in Mr. Warner's motion dealt with contacting the medical examiner's office regarding an update. This appears to be exactly the type of communication that the Youngblood court was referring to in not imposing an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance. I don't think it's been established here that the deleted text messages are even potentially exculpatory, as both detectives testified that they preserved everything that they believed had any evidentiary value. And there's been no indication that the police, by their conduct, have indicated that the evidence could form a basis for exoneration. Assuming arguendo that the evidence is potentially exculpatory, because some can take a broader view that we can't possibly know what we don't know or what the evidence is. It has not been established that the police acted in bad faith in deleting the text messages. The only evidence that they acted consistent with their training and experience in exercising discretion to preserve the items which they believed had some evidentiary value and not preserving the items which they did not believe had any evidentiary value. And so I don't think that there has been a Youngblood violation either. And so I would deny the motion for the spoliation instruction.
Thank you, Your Honor.
I believe that's all the motions that we had on the docket for today, unless I've missed some.
No, there are only two other items, if I may briefly address them. Just updates to the court more than anything else. So the court had requested jury instructions by January 7th. Ms. Wise and I have been communicating. I've sent her information. She sent them to me. We should be able to, I think, probably finalize anything going back and forth. And so the plan is to get those filed no later than Monday. So we would overnight them, and that way the court would have them. And then as it relates to witnesses, we received an amended witness list from the government last night. They took off one witness. We are adding that witness onto our witness list. So we will also overnight a copy of it to the court. We had put a general line in our witness list, essentially any witnesses on the government's witness list, but just to make sure it's very clear on who's being called by what party. We'll also make sure we add that to the proposed jury instructions, that we have a nice alphabetical list of the witnesses. So I just wanted to mention those two things. We are working on making sure that we comply with the court scheduling order.
Okay, in addition to overnighting your your jury instructions, can you email those as a Word document to Sierra so that she can start to put those together?
Yes, I usually do, even if it's not requested, because I think it has to be so much easier than retyping everything. So yes, I will do that.
Okay. All right, anything else that we need to address, Ms. Wise?
No, Your Honor.
Okay, I do owe you decisions on two motions the court previously heard and took under advisement. And since I had you here today, I think I'll just do that on the record rather than write an opinion. The first of those was the admissibility of some photographs that the court has now had an opportunity to review. Those were challenged by the defense. The first thing the court has to determine is that the photographs are relevant. Relevant evidence means any evidence having any tendency to make the existence of any factor of consequence to the determination of the actions more probable or less probable than it would be without the evidence, and that comes from MRE 401. The first thing the court has to determine is the materiality of the proposed evidence. In other words, whether the evidence was of consequence to the determination of the action. Materiality does not mean that the evidence must be directed at an element of the crime or applicable defense, but must at least be in issue in the context of the case. In a criminal case, all elements of an offense are in issue when a defendant enters a plea of not guilty, which is the case here. The prosecution, therefore, has the burden of proving every element of the crime beyond a reasonable doubt, regardless of whether the defendant specifically disputes or offers to stipulate to any of those elements. The claim that evidence goes to an undisputed point is inadmissible has also been rejected in criminal cases. For example, People versus Mills, 450 Michigan 61, People versus Meaton, 264 Mich 134, and People versus McPherson, 323 Mich 438. Mr. Warner in this case is charged with open murder and knowingly and intentionally removing, altering, concealing, destroying, or otherwise tampering with evidence. Photograph 1 in this case shows what the body looked like upon arrival to the medical examiner. It was covered in a white bag or tarp that must have been placed there by law enforcement, because it does not appear in the earlier photos when the body was initially discovered. For that reason, I don't think that photograph 1 bears on any fact that is an issue in this matter, and I don't find that photograph 1 is relevant, so I would exclude that one. Photographs 19, 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in a blue tarp as it was discovered and then removed from the tank. 20A and 20B are photos taken at the scene. 2A and 2B are photos taken at the medical examiner's office. Those photos all contain essentially the same information. They depict the state of Ms. Warner's body as it was found. I think these photos speak directly to whether her body, which is evidence in this case, was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 3, 4, 5, 6, and 7 depict the state of Ms. Warner's body upon being unwrapped from the blue tarp. They depict additional tape around portions of her body. These again speak directly to whether the body was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 8 through 17 depict the injuries that Ms. Warner suffered. That information speaks to the cause of death and to intent, which are both elements of the open murder charge. Therefore, I found those photographs to be material to this case. I'm going to hold off on photograph 18 because I have some additional questions about that. Next, the court has to determine the probative force of the evidence, whether the evidence makes a fact of consequence more or less probable than it would be without the evidence. Any tendency is sufficient probative force. As I've stated, the people must prove beyond a reasonable doubt that Mr. Warner caused the death of Ms. Warner and that Mr. Warner intended to kill Ms. Warner. These pictures, the pictures of her injuries, make it more probable that Ms. Warner was intentionally killed. And so I do think those photos have probative value. People must also prove that Mr. Warner removed, altered, concealed, destroyed, or otherwise tampered with evidence. And as I've said, Ms. Warner's body is evidence in this case. The pictures of where the body was located and the condition upon being found make it more probable that her body was removed, altered, concealed, or otherwise tampered with. And so I do find that the photographs have probative force. In determining that the photographs are relevant under 401, or after determining that the photographs are relevant under 401, the next question is whether the evidence must be excluded under 403. Under MRE 403, relevant evidence can be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. All evidence offered by the parties is prejudicial to some extent, but the fear of prejudice does not generally render evidence inadmissible. It's only when that probative value is substantially outweighed by the danger of unfair prejudice, that evidence should be excluded. Photographs are not excludable simply because a witness can orally testify about the information contained in the photographs. Photographs may also be used to corroborate a witness's testimony. Finally, gruesomeness alone need not cause exclusion. Photographs that are merely calculated to arouse the sympathies or prejudices of the jury are properly excluded, particularly if they are not substantially necessary or instructive to show material facts or conditions. If photographs which disclose the gruesome aspects of an accident or a crime are not pertinent, relevant, competent, or material on any issue in the case and serve the purpose solely of inflaming the minds of the jurors and prejudicing them against the accused, then they should not be admitted. However, if photographs are otherwise admissible for a proper purpose, they are not rendered inadmissible merely because they bring vividly to the jurors the details of a gruesome or shocking accident or crime, even though they may tend to arouse the passion or prejudice of the jurors. Generally, also, the fact that a photograph is more effective than an oral description and to the extent calculated to excite passion and prejudice does not render it inadmissible in evidence. That comes from People versus Eddington 387, Mich. 551. The photographs at issue in this case clearly show some gruesome aspects of the crime. They are, however, pertinent, relevant, competent, and material in that they directly address elements of the alleged crimes in this case. This is a proper purpose that goes beyond simply inflaming the minds of the jurors. The photographs have significant probative value that bears directly on elements of the alleged crimes. That significant probative value, I don't believe, is outweighed by any danger of unfair prejudice in this case. The court may also exclude evidence where it is cumulative. Photographs 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in the blue tarp. There does not appear to be any additional value or information to be gleaned from a review of all of them, and therefore I would limit the people to one of those 4 photographs, with the other photographs being admissible. I did say earlier that I was holding off on photograph 18, which is the photograph of Ms. Warner's right hand with some jewelry on it. And I was holding off on that, Ms. Wise, because I wasn't certain what the purpose of that photograph was or how it was to be used in evidence in this case.
Your Honor, one of the stories that the defendant told early on was that she's always wearing a bunch of jewelry and this would make her a target. Basically some stranger took her. So that would go to refute that argument, Your Honor.
Okay, Ms. Shardy, is there anything further you want to say on that issue?
So the issue of that would be Mr. Warner was asked repeatedly by law enforcement to try to determine where Ms. Warner was. So what does he think happened to her, or what could have happened to her? When listening to the interviews, Detective Greca actually came up with ideas that Mr. Warner shut down and said, no, that's not likely, that's not likely. So trying to answer law enforcement questions, and then the fact that she only has 1 ring or 2 rings on her hand, when he indicated that she does like jewelry, certainly is not relevant in terms of showing the photograph. The other thing is I think all of her children will admit she liked jewelry. And I think the detectives looking at the amount of money she spent at the jewelry store will affirm that. She spent a large amount of money on jewelry, which is fine. She liked jewelry. That's not a reason to admit a photograph of a hand from an autopsy photo with a ring on it.
What I'm going to do is hold off on making a ruling on that and wait to see how the evidence comes in at trial to be able to make a determination on whether or not there's relevance there.
Thank you. May I just confirm, so number 1 is excluded, 18, the court is holding off to determine what the testimony is, and then the government has to pick one photograph from 20A, 20B, 2A, and 2B?
That is correct.
Okay, terrific. Thank you.
Okay, and then the last issue was some statements about the purchase and use of a lake home and the admissibility of those statements. Under MRE 8033, which is the then existing mental, emotional, or physical condition exception to the hearsay rule. That rule allows statement of the declarant's then existing mind or emotional, sensory, or physical conditions such as intent, plan, motive, design, mental feeling, pain, or bodily health. In this case, we're talking about statements made in 2018 or 19 about the purchase of a lake home. I think that these statements are remote in time from the alleged crime in April 2021. While they do speak to Ms. Warner's plan to use the lake home as a safe house when the Warners had a fight, this was a plan that she had 2 to 3 years before the alleged crime. Her plans during that time, I don't think have significant relevance to the allegations in this case. Even if there is some relevance, I think that that relevance would be outweighed by the danger of unfair prejudice to the defendant, that the jury may consider it more as character evidence that since he behaved in a way that made her leave the home in 2018 or 2019, that he must have behaved in a similar or violent fashion in 2021. So I would exclude those statements from 2018. And so I think that brings us up to speed with all of the motions that were filed today or were previously pending.
Correct, Your Honor.
That's correct.
When Ms. Charday was asking for clarification, I didn't hear her bring up the other one, so I just wanted to clarify in the photographs that photographs 3 through 15 and photograph 19 are admissible. And I apologize if you said that and I didn't hear you.
So I had 3 through 17 being admissible, 1 of 19, 20A, 20B, 2A, and 2B, and then reserving a decision on 18.
Thank you, Your Honor.
All right, I think we're all set for today. Thank you.
Thank you, Your Honor.